Hello, everybody, and welcome to our Boilerplate series. This is an occasional series about boilerplate and contracts. I'm David Lowe. I lead our commercial contracts team, and I focus on the non-contentious side, reviewing and negotiating contracts, and therefore, of course, as part of that, making sure I've got the boilerplate right.
And I'm Sean Adams. I'm a partner in our commercial disputes team. I often see contracts from the other end of the telescope. And by the time something's going wrong, somebody's looking to terminate, dispute has kicked off. Some of that boilerplate that you carefully put into your contract with David 3 to 5 years before can come in really useful. So that's the perspective I'm here to add.
And of course, part of today is about giving you a bit of a guide to why boilerplate's there, when is it important, when is it useful, so that you can make the judgment about whether to include it. If you're trying to draft a very short contract or the other party is not willing to add in some boilerplate, does it really matter? And in today's session, we're going to concentrate on a batch of issues around construction and administration of the contract. And so we're going to cover things like the recitals, the entire agreement clause, severance, waiver, variation, notices, and further assurance clauses. So the sort of really boring bit of the boilerplate, really, deep in the back of the contract, is what we're going to look at today. So Sean, I think we're going to start with recitals. So having talked about the back of the contract, actually we're going to start with something at the beginning.
We are. We're going to start right at the front. Usually the first thing that follows the parties in most contracts, you normally get the names of who's involved and then you go straight into recitals. And I think probably the overarching thing to say, picking up on your comments around, sometimes you'll want a short contract and you don't want wealth of boilerplate in there. You don't need recitals in a contract. I think quite often people put them in as a matter of course these days, but you certainly don't need them to be in there. They can be really helpful, particularly in sort of wider relationships or relationships that are changing over time or agreements that are being entered into in specific contexts. Having a recitals clause in there that just in one or two paragraphs or sentences explains why the parties are entering into this agreement can be really handy. But there are a couple of sort of slightly techie pitfalls that you can fall into, which is why we've got this clause on the slide, because sometimes you end up with recitals and operative clauses that conflict with each other or aren't clear, or you see definitions tucked away in the recitals that nobody's then thought about properly in terms of how they track through. And so we just wanted to very quickly mention that if you're going to use recitals, I think a couple of top tips: make sure they're accurate first. I think if you're going to put any defined terms in those recitals that are then used through the operative part of the agreement, and that does quite often happen because by virtue of where these recitals appear in the agreement, it's usually the first time you've started talking about something, and therefore the natural instinct is for the lawyer to define something as soon as they see it. A technical argument about the fact that that might not necessarily make them part of the operative contract, those definitions, and so best practice is probably to repeat those within a defined or definitions section of your contract, which you probably also have. I think it'd be a pretty harsh result where you've got a clear defined term in a recital, which isn't redefined elsewhere in the agreement, to say that that doesn't apply. And also just be very careful around clarity. Obviously, the litigator in me make sure the entire contract is crystal clear, and so that you don't end up with any problems at all. But as you can see from the slide there, where you have a very clear recital and an unclear operative term, it might be the recital that you fall back on as being the binding obligation, which a court would look at and say is the clear basis of the agreement. Otherwise, generally, the operative terms of the agreement, so everything that's not in the recitals, is going to be preferred by the court. And that's particularly the case in that last scenario you've got on the slide there, where you've got a very clear recital, a very clear operative provision, but unfortunately they're saying two separate things. I think the court's impetus is going to be on the operative provision there. Anything else you wanted to add on recitals, Dave, before we move on?
Yeah, just to add that I see a lot of contracts with recitals that add nothing, and therefore they risk confusion and certainly take up space and time. So do think about deleting the recitals from really routine contracts, because there's no point to them. But having said that, as Sean said, where you've got a complex scenario, recitals are really, really useful. Yeah, and I was looking at a contract recently, which the recital told me that there was another separate contract which was going to be really relevant. In fact, if the recital hadn't mentioned it, because it's not mentioned in the operative aspects of the contract, I wouldn't have known there was another contract out there that I needed to also look at, which was relevant to the relationship between the parties. So that's an example when the recital is really useful, capturing that memory. Should we go on to entire agreements?
I think so.
So at the back, somewhere in the back of the agreement, there is often an entire agreement clause. And the reason it's there is to try and make it clear that the entirety of the relationship between the parties is set out in the contract, and to try and stop litigation coming up where allegations are made about representations, perhaps that a supplier had made in the tender, or other promises that were made in the negotiation. Trying to say the contract is contract. That's what we've all spent a lot of time on. That is king, and nothing else applies. And obviously, for those of you drafting negotiating contracts, that makes a lot of sense, because normally, if we've gone to the trouble of negotiating and drafting a contract, we want the contract to be king. Now, so therefore, it's very common to say, you know, the entire agreement is this contract and nothing else applies. Problem is that actually by doing that, you're then excluding liability. You're excluding responsibility for misrepresentations, for example, that may have been made in the negotiation. And therefore, the court looks at an entire agreement clause as an exclusion clause, and therefore they'll read it against the person seeking to rely upon it. They'll try working around the entire agreement clause when it suits the court, where they feel that would serve justice. It risks the application of the Unfair Contract Terms Act, etc., etc. And so, therefore, I've seen quite a lot of case law around entire agreement clauses over the last 30 years. Contracts typically started off with something very much like the first paragraph here, just simply saying this is the entire agreement. But then cases came along saying, oh, well, what you haven't said, though, is that you can't rely upon any representations. And so, because you didn't say that, it doesn't exclude those representations, which obviously undermines the whole point of the entire agreement clause. So that's why you then got very much a clause added in, like the second paragraph, which talks about being in reliance on representations, to make it clear that we are excluding each party's reliance upon those representations that have been made, and therefore the remedies for misrepresentation do not apply. Then you had cases saying, oh, well, it looks like you're excluding liability even for fraudulent misreps, and that's not enforceable, and therefore the whole clause falls down. So that was why in the late 90s, you started seeing introduced the third paragraph about making it clear we're not excluding liability for fraudulent misrep, and therefore to try and ensure that the clause stands. So that's already getting quite long. And then there was yet more case law, and this is where we run out of space on the slide, is that there was then case law saying, but you haven't expressly excluded the right under the Misrepresentation Act to rescind a contract in certain types of misreps. So you then add another bit to this clause which says, and the parties exclude their right to rescind the contract. So that means, unfortunately, for an entire agreement clause to have a good chance of being enforceable, it ends up having to be quite long. Now, I'm not saying don't use short entire agreement clauses. You can do a short entire agreement clause that's just the first paragraph here. But if you do that, then you're taking quite a risk that a court presented with arguments about representations that are made in a tender or in the negotiations might feel that actually, because you haven't got everything else, the entire agreement clause is unenforceable. And then you're going to be fending off somebody like Sean pursuing you on a misrep claim, saying, aha, the entire agreement clause doesn't work. And so, for at least for substantial contracts, that is quite a risk, and one not to be recommended.
Yeah, I'd agree with that, David. I think unlike some of the clauses we're going to talk about where we're going to say if you don't have those in your contract, then so be it, and the law will step in some ways anyway. I think this is a particularly important areas, particularly in those big contracts where you're negotiating and drafting. And if you're talking about a very large contract anyway, yes, these clauses end up being a bit long and unwieldy, but in the wider scheme, probably not problematic. And there really is legal merit behind those extra elements that have been built into these clauses now. They really are doing something. So definitely worth looking at carefully, leaving them in, and realizing that these sorts of clauses really are giving certainty and privacy to the contract. But as you say, most of our clients, that would be precisely what they're looking for, and spent the time to negotiate one properly. I wanted to touch very briefly on two other clauses that you can probably group into the construction category, because they go to the question of how this contract is construed should you ever end up in a fight over it. The first is a severance clause, and that's the clause you're probably familiar with seeing, that says in the event that any clause of this contract is found to be unenforceable, then it can be struck out and the rest of the contract survives. That is a clause that is actually just reflecting the legal position in the England and Wales anyway. If you've got one clause in a contract, with some exceptions, and provided you're not striking out an absolutely key clause which is going to otherwise completely obliterate the purpose of the contract, generally a court will look at an unenforceable provision in a contract between two parties, and if that provision is unenforceable, there is a blue pencil test that can be applied with a couple of additional conditions to strike out that particular offending provision without impacting the rest of your 30-50 page contract. You do sometimes still see people drafting those clauses in, and they can be helpful because they can help a court having to come to that conclusion to say, hey, you know what, the parties always envisaged that this might happen, and that, you know, a couple of these provisions that were maybe over the line or just a bit too far, or the parties pushing their luck a little bit, they can come out, but the rest of the contract survives. So it can be a helpful clause because it can give the court that extra basis upon which to say, I can do this, in order to come to the conclusion that the parties were really trying to reach. But I would say not essential if you're trying to do one of those short form contracts.
Yeah, definitely. If I'm doing a short form letter agreement, severance clause is certainly one of the first ones going into the bin, basically, because I'm trying to keep my agreement to two sides. I haven't got time and space for something that's nice to have.
But I suspect you're probably coming to the same conclusion on that no waiver clause, which is the clause in those agreements that says, if I have a right and I delay in exercising it, or there's a breach and I delay in calling you on it or exercising a termination right, I'm not waiving my right to do so. Again, I think they can be helpful. They can give the litigators something to argue off the back of, where you've got a bit of a longer gap than you might like between something occurring and you electing to do something about it. The ability to point to a clause that says, look, we did agree between us that we didn't have to act immediately to ensure we weren't waiving our rights. It can be a helpful arguing point. It's only going to help you so far. If a breach occurs and a right arises, and then you sit on it and wait for 18 months, trying to turn around and say, well, I had a no waiver clause, judge, so I shouldn't be taken to waive my rights and any action I can take here, I think you're unlikely to succeed on that. So nice to have in a contract, and in a big supply agreement, for example, a long-term relationship, it can be useful because it can put a few parameters around how the party's going to act, but certainly not a watertight bulletproof clause in terms of getting you out of jail free, I don't think, if you don't take any action.
There was a nice example. There was a post office tele-reel case where there was an obligation to provide a parent company guarantee by the supplier. At the time of execution, the post office didn't ask for the parent company guarantee, didn't pursue the supplier for the parent company guarantee for some time. It took 11 months before the post office woke up and said, oh, where's our parent company guarantee? The supplier said, well, you've waived that right. 11 months is far too long. Post office points to the no waiver clause, saying, well, we didn't do that in writing, so we haven't waived it. It went to court, and the court said, 11 months, come on, of course you've waived it. Whatever your contract says isn't going to rescue you from this. And so therefore really emphasises nice to have clause, but not as good as excellent contract management.
Absolutely right. And contract management is probably a nice segue onto some of the points we wanted to touch on contract administration.
Yeah, so we put this as administration because they're about running the contract, the day-to-day stuff. So how do you vary it? What about notices clause? What about further assurances clause? What does that mean? So I'm going to start with variation. Now, variation used to be quite nice to have clause. It used to just say, the party can't vary it except in writing, and it needs to be signed by maybe two directors or authorized signatory. But the case law, if you go back in time, sort of just saw that as a sort of signpost really to how people could vary a contract and accepted that people could vary it in other ways. So they might do it in writing but not sign it, or they might do it orally, a note or over the phone or whatever. And then there was a really, really important Supreme Court case, Rock Advertising, which said no, if you've got a clause that says the contract can only be varied in a certain way, it means it. It means you can't vary it in another way. And therefore, we're going to stop all these arguments going on where people are saying, well, I just ignored the clause and varied it anyway. That doesn't work. And so what that means is that if you are to vary a contract and the variation is to be enforceable, you must comply with the variation clause. And so if the variation clause says it must be signed in purple ink in triplicate and by two directors, both of whom names begin with the letter D, then you must comply with that, otherwise it won't be effective. Now, of course, in the real world, usually the contract will say it must be in writing, and then it will say signed, and it might then signed by a director and authorized signatory, but you need to tick all those boxes if the variation is to be effective.
And I think the only thing I'd add there is that's when it's really important to make sure that the people running your contract on a day-to-day basis are fully aware of what they need to do to vary it if that is something that's likely to occur. The contract sitting in a drawer with a very nicely drafted no variation clause is usually great until it turns out that actually the people operating that contract have thought they'd varied it 6 times in the last 12 months, and you get to a dispute and it turns out you're in a very different place because none of the formalities were followed. Probably a saving grace in that scenario that Rock Advertising left open estoppel arguments. So we're going to see a lot more of those coming through. But yeah, certainly the trend is in favour of those clauses work and the court is going to enforce them. So if you put one in there, make sure you know what it says and make sure you follow it.
I think the people drafting and negotiating contracts, we want this kind of clause in there to try and encourage good contract management, because arguing over an oral variation is pretty messy. It's very difficult to prove who said what when. So although if a contract is badly managed, a variation clause might stop certain arguments and that might be unhelpful in the future. I would say overall, achieving contract certainty and encouraging good contract management is what we should all be aiming for. And therefore, I would encourage inclusion of a variation clause. The other clause you often find at the back of the contract is something about notices, which says if you want to give a contractual notices, this is how it's going to be done, and it can be done in person, it can be done by post, it might express to you email. 2 really important points about that. Sometimes, often the notices clause says certain things that must be done in a certain way. So the normal thing is a notice must be given in writing, and it might then explain whether email is included or excluded. If the contract says something must be done in that way, then you have to comply with it. So often the notice clause starts off with saying what you must do. Then it goes to how you may serve a notice. So all it does is create a signpost as to how you could serve notice, but it doesn't exclude you from serving notice in other ways. And that's, Sean, quite important for you, isn't it, really? Is that faced with having to serve a difficult notice, having flexibility is quite helpful.
Yeah, it is. And the scenario in which you often see this arises around termination. And particularly if you have one of those contracts that says the term is going to roll for another 12, 24 months unless you terminate by a certain date. If somebody's not given a bit of thought to your notice provision at the time when drafting that particular clause, and you leave it too late, and particularly if it's very difficult to achieve service of a notice, or if there's a deemed receipt provision that says no matter when you send it, it's only deemed received 5-7 days later, it can just create a few headaches. So just give some thought to your notice clause. They're useful to have in most contracts. They're certainly worth including, but just make sure they're accurate, make sure they're thought through as regards the rest of the contract, and make sure they're updated. I've not seen facts for a little while, but you'd be amazed how often you still get fax notice clauses, and I'm not sure I'd know where our fax machine was.
Yeah, so please do scrap the references to facts, or even I've occasionally seen references to telex, which is even older. That's obviously really unhelpful. Make sure your clause is up to date and is realistic.
Yeah, and I think just very finally to touch briefly on further assurances clauses, those are the clauses that you find in the contract that say essentially the parties will work together to complete any additional requirements to fulfill the obligations above. Essentially, the clause that you can sometimes see people trying to rely on in order to say, well, we forgot to specify that you had to do X, Y, or Z in the contract, but you gave me a further assurances clause and I need this particular notice or I need this particular certificate of confirmation. I think they fall firmly into the nice to have category. Again, they can create some scope for argument, but of course not going to use a further assurances clause to create a whole host of freestanding obligations on a party. It's going to look to the rest of the contract and where there is specific things you want and need under a contract, much better to spend the time spelling those out higher up in your operative provisions to make sure you get what you want.
Great. Well, thank you everyone for listening and watching us do this today. If you found this useful, then do think about signing up to ThinkHouse, our program aimed at in-house lawyers. Content we've covered today is typical, the kind of issues we tackle in ThinkHouse, often in more depth. So if you're in-house law, do please sign up to it. And of course, if you've got any questions, feel free to get in touch with us. We'd be very pleased to hear about the contracts you're doing, the challenges you're facing, and we'll do our best to help. Thank you very much.